Thank you, Senator Kennedy. I'd like to ask unanimous consent to enter into the record a report on the nomination of Judge Kavanaugh by the Lawyers Committee for Civil Rights Under Law and by the NAACP Legal Defense and Educational Fund.
Without objection.
Mr. Dean, thank you for your written testimony and for appearing before us today. You alone in this panel have the unique historical experience that I think is directly relevant to the question of what happens when presidential power is unchecked and a president is not accountable. Based on your experience, what are the dangers of a presidency that doesn't face strong checks in the Supreme Court and Congress? And what would have happened in Watergate if President Nixon had been able to avoid compliance with a subpoena, or if he'd been able to fire the special prosecutor without some consequential response by Congress?
Well, of course, when he when he fired the special prosecutor, he reacted to the negative publicity that it generated and the interest of Congress suddenly in impeachment. So he thought he could possibly stem that tide by bringing a new, he thought it initially, favorable and maybe not as aggressive investigation with the appointment of Leon Jaworski. The second special prosecutor, however, was equally as effective as the original one, Archibald Cox, which I don't think the White House had anticipated. As far as the courts and the rulings, we would have had a very different history had the Supreme Court not dealt with the tapes case as they did. It would have resulted in Nixon surviving. Without the tapes, it was my word against his, and in the polling, while I was out polling him at times, it wasn't enough to resolve the problem.
So without the smoking gun, which was made possible by the Supreme Court's decision in U.S. v. Nixon, presidential accountability might not have occurred. We might not really know what role the president had played, and we might not have avoided the constitutional crisis of both confidence and we might not have removed a criminal president. Professor Shane, I questioned Judge Kavanaugh fairly aggressively on his view of the scope of presidential authority. Based on his writings, his speeches, his opinions as a judge, I'm concerned he has a view of presidential power that's dangerously unbounded. You've had a chance to review his work. Do you share my concerns? And what do you make of his enthusiastic and repeated embrace of Scalia's dissent in Morrison?
There's a lot to that question, Senator, so I'll try to keep it brief. What most concerns me about Judge Kavanaugh's position is not just that he has embraced the tenets of unitary executive theory, but that he has gone to such lengths to try to create a kind of legal foundation for it in the D.C. Circuit in cases that had nothing to do with unitary executive theory. There was much discussion during Mr. Olson's panel about the case of Morrison versus Olson. And Judge Kavanaugh, of course, has famously said that he would like to put the final nail in that case. But in the PHH case that was being discussed, this was a case that the D.C. Circuit unanimously resolved on purely statutory grounds. And Judge Kavanaugh saw fit to write an extensive opinion for the panel. On the constitutional issue, it later got overturned on bank. But the opinion he issued for the panel pulled out of thin air this completely unmoored theory about why a single-headed independent agency was unconstitutional. It was full of arguments that would be perfectly fine for Congress to entertain as a matter of policy, but they have nothing to do with the Constitution. With regard to Morrison versus Olson, it is still good law in the Supreme Court that independent agencies are constitutional. Whether they are a good or a bad idea is up to Congress, which has the power to make all laws necessary and proper, not only for carrying into execution the powers of Congress, but the powers of all officers and offices of the United States government.
Thank you, Professor. If I might, a last question to Professor Hinterling. Since we went around and around about this several times, Judge Kavanaugh and myself, in trying to explain his reliance on or his interest in, or I would say his fixation with Scalia's dissent in Morrison, Judge Kavanaugh tried to describe it as sort of a one-off case about a now expired independent counsel statute. And I kept coming back to this dissent in PHH, which Professor Shane was just referencing. Do you think that dissent lays out the unitary executive theory and displays some significant enthusiasm for it that is a well-founded justification for my having concerns about Judge Kavanaugh's views on presidential power?
Absolutely.
Professor, if you could, just to be fair to everybody, if you could give us about 30 seconds.
Yes, absolutely, yes. He would have struck down a major federal statute that was very new, that set up the Consumer Financial Protection Bureau, in which Congress had made a judgment about the degree of dependence and the structure of the agency that was necessary in order to counterbalance the power of the financial industry. And he wrote a dissent from an en banc denial in that case. So yes, absolutely, you are right to be concerned.
I'd like to thank the whole panel and just conclude by pointing out that the reason I raised these concerns in pressing Judge Kavanaugh was that it's exactly his quotes about U.S. v. Nixon, his dissent, his enthusiasm for the dissent in Morrison, his dissent in PHH, that leads me to still have concerns that he would not hold the president accountable to an investigation, to a subpoena, or to testimony in a way that we need in our current environment. Thank you, Mr. Chairman.